Welcome to the Institute of Advanced Legal Studies. Thank you very much for coming this evening. I'm Diamond Ashiagbor and I'm Professor of Law and Director of Research here at the Institute. And as you know from this sign here, we're celebrating the 70th anniversary of the Institute. We're hosting a series of events, and this one is on the contribution of the Institute to legal scholarship. The IALS is contribution to legal scholarship. So tonight's event is a celebration of the role the Institute has played in changing the way legal academics engage with research, but also how the broader legal community thinks about legal research. As you know, the Institute was conceived and funded as a national academic institution. So it was attached to the University of London, but it has a national and even international remit, serving universities through its programmes, facilities, and crucially its National Legal Research Library, which is easily one of the largest law libraries in the country. So its function is to promote, facilitate, disseminate the results of advanced study, hence the name, in the discipline of law for the benefit of persons and institutions in the UK and abroad. So why focus on legal scholarship and the Institute's contribution to advanced study? Well, a shift has occurred since 1947, but I would argue, and I hope this evening's contributions, I'll introduce the panel members in a minute, will show you that the Institute has had quite an innovative and pivotal role in changing what we think of as legal scholarship. So, for example, legal academics themselves come to think of themselves as scholars and researchers who, from that foundation, then might engage in legal practice, rather than primarily as practitioners or ex-practitioners who teach. For example, the Institute was one of the first institutions to host academic legal conferences as we know them. Now we call them the WG Hart Workshops, funded initially by the Ford Foundation from 1966. And the topics of some of those workshops, 1967 on labour law, organised by Bill Wedderburn, 1975 on what was then European Economic Community Law, organised by Francis Jacobs, Professor Francis Jacobs, who then became one of the UK's Advocate Generals, the European Court of Justice. And then more recently, conferences, two organised by two of our panellists tonight, on criminal justice and legal education. A lot of those conferences, the themes of them, became the starting point for thinking in a scholarly way about those disciplines. So both in terms of bringing together scholars, practitioners, members of the judiciary, and then the publications that came out of those conferences, but also more broadly in providing a home and meeting place, literal but also figurative meeting place, to think about law and to engage in advanced study of law. So, for example, doctoral study was unknown of in the legal academy, and the Institute's move into doctoral studies and more recently research training and research methods training could be said to be pioneering developments within legal academia in the UK. So there have been so many changes since the 1940s and 50s. So, for example, the expectation that legal academics should now have doctorates, and increasingly now that we're expected to attract external funding. But I hope what we can explore tonight is the more benign and positive contribution of the Institute to this sort of rapidly changing world, perhaps even shifting away from, even if there ever was a golden age of pure scholarship, perhaps enabling legal academics to come together to celebrate that. And I think also engaging legal research which develops the discipline but also speaks to the wider world in terms of promoting new research agendas in specialist areas of law, such as, for example, legislative drafting, bringing together scholars and policymakers, for example, in the Institute for Information Law and Policy, And going into the future, thinking about this institute being at the forefront of interdisciplinary research in law, society and the humanities, which links us in with the Humanities Institute of the School of Advanced Study, of which we're part. Okay, so I'd now like to introduce our three panel members for this evening's discussion and reflection. I'll introduce them all in the order in which they're going to speak. First, we have Professor Fiona Cownie, who's Professor of Law at Keele University and has been since 2006, having previously been the Hugh Bevan Chair of Law at the University of Hull. Fiona became Pro-Vice Chancellor at the University of Keele in September 2013. Her research interests centre on legal education and the legal system. She's written on the purpose of the law school and on relationships between the academic study of law and vocational training as required by a legal profession. So I think of Fiona's work when I think of first week of talking to law students. Why are you doing this subject in a university rather than in the old days, sort of Kensington time, going straight into practice? What is it that we mean by studying law in a law school? Fiona's work has been really pivotal in that process of analysis. Second, Professor Valsamis Mitsogalis, who's Professor of European Criminal Law and Dean for Research in Humanities and Social Sciences at Queen Mary University of London, where he also, since 2012, has been Head of the Department of Law. He is also Inaugural Director of the Queen Mary Institute for the Humanities and Social Sciences. His research interests and expertise lie in the fields of European criminal law, migration, asylum and borders, security and human rights, including the impact of mass surveillance on privacy, legal responses to transnational crime, including organised crime. And Valsamis was one of the academic organisers of WG Hart Workshop in 2012 on globalisation, criminal law and criminal justice. So criminal law is something which often we think about as territorially bounded, taking place or being regulated only within national borders. And Valsamis's work has been very much globalising criminal law, since after all criminal activity is global, so we need to think about law in that more global sense. And our final speaker this evening is Professor Hilary Summerlad, who's Professor of Law and Social Justice at the University of Leeds. Hilary's background has been in history and political science before switching to law, and she's worked previously at Leeds Beckett, Leicester and Birmingham universities. Her research interests are in legal professional culture and the impact of macro-level changes from the nature of the state and understandings of citizenship to the increasing diversity of the people who do law work. And so, using that phrase, law work, she defines engagement more broadly than just legal practice. She's undertaking funded projects on professional diversity and access to justice, and is currently editing a major international study of lawyers and society. So again, when I think about Hilary's work, I think of law schools and legal practice being at the forefront of this phrase, which I really don't like using, I think Hilary probably agrees with me, which is diversity. There's all kinds of reasons why equality lawyers don't like using the word diversity, but one aspect of Hilary's work is, what does it mean to think about a more diverse legal profession, but also what does it mean in terms of who engages in practicing and teaching and writing about law, not just the people in terms of ethnic and racial and gender diversity, but does that change what we understand by legal reasoning, for example? So that's one of the questions I think about when I engage with Hilary's work. So this evening we're going to be focusing very much on all of that scholarship and broader scholarship, but coming through and out of this institute. So I now want to hand over to Professor Fiona Cownie.
Thank you very much. So I'd just like to thank Diamond very much and your colleagues at the Institute for inviting me to contribute to these 70th anniversary celebrations. I feel very privileged and honoured to be asked to speak this evening. So thank you very much. Like many of us, I have known the Institute since I was a postgraduate student. I did an LLM at the LSE, and the Institute was a favourite place to revise for my exams. That wasn't a favourite occupation, but this was a good place to do it. The Institute has been a continuing presence, really, in my academic life ever since. I'm very proud to be associated with it, but this evening I really want to think not about my personal experiences, but instead about the role of the Institute in supporting legal scholarship across the world by its interaction with various professional organisations. So those of you who know me will know that I've been associated with various different legal professional associations in various different capacities for some time, and I thought it might be a good opportunity to think what the Institute has done in cooperation with those associations over the years to foster legal scholarship. So as you know, there are 3 professional associations of academic lawyers in the UK. The Society of Legal Scholars, founded in 1909, is the longest established, followed by the Association of Law Teachers in 1965 and the Socio-Legal Studies Association in 1990. So each of those associations has had a close relationship with the Institute. And I want to think for a few minutes about what this means for scholars around the UK and indeed around the world. So, just thinking historically for a little while, discussions about the establishment of a Centre for the Promotion of Advanced Legal Studies took place as long ago as the early 1930s, which you'll notice is more than 70 years ago, when the then Lord Chancellor, Lord Sankey, appointed a committee under the chairmanship of Lord Atkin to consider the organisation of legal education in England with a view to providing close coordination between the work done by the universities and the professional bodies, and also to consider the provision of advanced research in legal studies. In its report, the committee recommended the establishment of the Institute, which it envisaged would be an institution which would be a headquarters for academic research and would promote the advancement of knowledge of the law in the most general terms. So even at that early stage, there was considerable support for the idea from the Society of Public Teachers of Law, as it then was. Minutes of the Society's General Committee record that Professor Lee of Oxford was particularly enthusiastic about the idea. He said, "If I may add my personal testimony, I have conversed with foreigners, not to be dismissed as mere visionaries, who believe that London has a mission to perform as a centre of legal research for the whole world. The idea is inspiring." Now, one may balk somewhat at the somewhat imperial implications of that remark, but nevertheless, the ambition to be open to scholars from around the world, I think, is a positive aspect of that kind of attitude. So that was one of the main ideas of the Institute from the very beginning, and I think it permeates everything it has done since. So the advent of World War II somewhat interrupted the development of the Institute, so of course the committee ceased its work during the war, but the subject was raised again in the immediate post-war period. However, as Professor Gower reported with some irritation, I thought, in an article in the Modern Law Review in 1950, in a written reply by the Attorney General to a question in the House of Commons in May 1947, the government's attitude was not at all helpful. The Attorney General's view was that the recommendations of the Atkins Committee as regards an Institute of Advanced Legal Study had been implemented by the appointment in 1938 of a further committee to consider its establishment. He continued, "That committee," remember this is 1947, "has not yet reported. It suspended proceedings in February 1940 and has not yet resumed operations. Having regard to the urgent need for reconstructive activities in other directions and to the government's legislative programme, the time is inappropriate for the resumption of the committee's operations or the setting up of an Institute of Advanced Legal Studies, should such a course be recommended." So that was a kind of kick it into the long grass type answer. However, fortunately for us, the University of London decided to establish the Institute as part of its post-war development programme. So, in its first prospectus, the aims of the Institute were stated as becoming the focal point of legal research for the United Kingdom and the countries of the British Commonwealth. In addition to formal instruction, it will provide a meeting place for teachers and research workers from universities and colleges, and great importance is attached to the opportunity afforded for personal contact. So some of these words, I think, really speak to our condition now. That is what the Institute does, I think, for many people. I think the subsequent history of the relations between the Institute and various professional associations reflects the efforts of many directors of the Institute and their colleagues to remain true to those founding principles. As the only organisation of academic lawyers in being until 1965, the SPTL was naturally the first organisation to which the Institute turned when seeking to engage with legal academics in the UK. The closeness of the relationship between the SPTL and the Institute was emphasised in 1968, when the then director of the Institute, Professor Norman Anderson, became president of the SPTL. In his presidential address to the Society, he talked about the law in its wider setting, what we today might call law in context, which had been a topic occupying the SPTL throughout the decade. Professor Anderson naturally stressed the role that the Institute had played in promoting interdisciplinarity, noting in particular what he termed the experiment carried on throughout the 1960s at the Institute, whereby a number of interdisciplinary discussion groups had been formed, beginning in 1960 with lawyers and economists, followed by lawyers and sociologists, a group which also contained a kind of ragbag of other disciplines, including psychologists, psychiatrists, and, it says, others. Then lawyers and theologians, and finally lawyers and criminologists. While these were closed groups and some might question their lack of openness, nevertheless, it's an interesting development in terms of the relationship between the Institute and professional associations, reflecting the way in which the Institute was aware of current academic debates around interdisciplinary research and took action to promote it. That willingness to engage with contemporary academic debates remains, I think, a hallmark of the Institute's engagement with professional associations. Having only limited time, I want to turn from those very early relationships, which I think, signalled the direction of travel, to consider ways in which the Institute currently uses its relationship with various professional organisations to facilitate participation in the development of legal scholarship by all legal academics in the UK and beyond. The Institute offers facilities to all the law academic associations so that they can hold workshops and seminars here in Charles Claw House, working in cooperation with the Institute, which acts as host to these events. You can look on the website and find many recent examples of such cooperation. There's currently the SLSA, IALS, British Library workshops on various research topics. Recently there's been an SLS conference on the future of legal education. There have been a large number of workshops organised in cooperation with the Legal Education Research Network, which is co-sponsored by SLS and the Association of Law Teachers. So the importance of this role of fostering cooperation with professional associations, I think, cannot be underestimated. Nowadays, it provides the opportunity for legal scholars from the UK and beyond to meet and debate current issues, and thus really does perform the function envisaged by the founders of being a hub for legal scholars and promoting the advancement of the knowledge of law in the most general terms. This is further facilitated by a number of other different kinds of association with professional associations. So you may or may not know that Jules Winterton chairs the Society of Legal Scholars Library Committee, which is responsible for making extremely useful periodic recommendations about law library holdings. Those of you who have been heads of school in a law school will realise how very useful that document is when bargaining about resources with universities. So for legal scholars, the cooperation between the institute and the academic associations is a vital part of academic life today. But that life is also enriched by the quality of support received from colleagues working at IALS, several of whom play significant roles in other professional organisations. And I'm thinking, for example, of involvement in the International Association of Law Libraries, IAL, I discovered it was called. So Jules is a former president, David G is the current secretary to that organisation. I'm sure there are other colleagues in the Institute who are also active in other similar organisations of which I am totally unaware. Involvement in these organisations isn't just convenient for my talk because it comes under the heading of professional organisations. It reflects the esteem in which members of staff at IALS are held by their colleagues and the legal academic community. And the legal academic community itself gains a lot of benefit from their involvement in their own professional expertise and associations. I just wanted to finish by saying that the benefits to individual legal scholars of the relationship between the Institute and legal academic associations is all the greater because the Institute remains very open to suggestions from anyone in the legal academic community for joint events. The Institute has an important role to play as a facilitator for legal scholars in the UK and around the world, and its cooperation with the legal academic associations that I've outlined this evening supports that aim very successfully. So thank you very much, Institute.
Professor Mitzi-Galish.
Thank you very much for the invitation. It's a pleasure and an honor to be here, and I've learned a lot from your presentation. I chose the easy route to be autobiographical, and everybody, maybe just myself, likes talking about themselves. But I think when Diamond invited me, you made me think about what can I usefully contribute to today's seminar, and what is the Institute's contribution to legal scholarship. And I approach it from the perspective of the question of who is the Institute for, so who benefits actually from the work of the Institute. And then I started thinking of my association with the Institute for the past 20 years, and I realized that actually you serve multiple constituencies, and this is one of the, I think, great advantages and the unique, if you like, features of the Institute, that at the same time you are here as a hub for different categories of scholars, academics, students, and so on. So I first came here 20 years ago. I was an LLM student, not in London, in Kent, and in those days it was when research components have been slowly introduced into academic degrees, especially postgraduate degrees. So we had to write a 20,000-word dissertation over the summer, and the Institute was a lifesaver for me, so I spent most of my summer here. It was nice also to be able to come over to London, but already from then, that was, and Fiona mentioned the word a number of times, that was really a hub for postgraduate students, and it continues to be. It's not only the quality of the service, it's also that, and this goes without saying, and we do not mention it expressly, but this is really a fantastic library. It's a world-class law library. It's a very big selling point, but it's also great for the users. After that, after 7 years, I joined Queen Mary in 2005, and one of the first administrative roles, or as they're called now, leadership roles that I had to undertake in the university, was to be the co-director of the LLM program in the period of where the London Intercollegiate LLM collapsed. So I was there for 4 years, from 2005 to 2009, and for Queen Mary the challenge was to launch, if you like, a new LLM program, and at that point nobody knew how it would work out. We had to dismantle quite a successful and very collegiate program, and each of us went on their own, and we were wondering really whether we would have any students when we would launch the programs. And the Institute has been really instrumental to our success. having the space, being able to rely on the library, but also to rely on the space as a social space for our students. Even now, my college is, I think, the college which uses the Institute more than any other college, and we are also contributing more than any other college. But I want to say this just demonstrate how crucial the Institute is for our well-being, for what we offer our students. It's really part of our identity in our day-to-day life. It's something integral, actually, to our experience and to the student experience. But if you take students out, Diamond very kindly mentioned that I had the pleasure to organize one of the Hart Workshops in 2012. That was not my first participation in these workshops. I participated twice more earlier on workshops on cultural diversity and on immigration. And I think you're right. The workshops are, first of all, a celebration of cooperation between academics from different London colleges as well, in terms of organizing them, but also bringing together academics from all over the world. The format of the conference gives you freedom, and also I think most of the organizers every year strive to be cutting edge in one way or another. So as you mentioned, we tried, this was, when we organized this, we were aiming to do something which we felt was very important but under-researched, and this has generated also a series of research activity afterwards, which is common, I think, with the workshops here, edited volumes, journals, special issues, and so on and so forth. And it generated also a global conversation between the people who came here. We tried consciously also to include panels for PhD and early career researchers within the workshop, which I think is a very important contribution on the Institute. I continue to use the Institute as a scholar. I don't have much time to come to the library now, although I should. I think probably next year, hopefully. But it is also a hub. On my way here, I bumped into one of my PhD students who was here, trying to delve into archives about, home office guidance on detention and removal of irregular migrants. And so the Institute is the first port of call, and we send our PhD students here for the intensive PhD training in January, and again for a PhD community, this is really an invaluable resource, both in terms of access, but also in terms of the socialization point, which I think is a very big feature of the Institute for all of us. As head of school, this is a concern, how to make our students have the best access, and for a postgraduate cohort, the Institute is an invaluable resource. But also, and I had the pleasure of serving on the advisory board, what the pleasure there, I think, is to try to take this conversation further, to develop further bridges, further avenues of communication and cooperation, also among the London colleges, although this is a national and international institute. I think in London increasingly, work gets so busy, and we work more and more in silos in our colleges, and we lose, I think, this element of collaborative research and collaborative, if you like, collegiality. And I think the Institute is perhaps the strongest forum for us to get together, even tonight. I think it's a great occasion, and to meet each other and to talk to each other, because it's not always easy. Maybe I feel a bit too isolated in my land, but maybe colleagues who are more in central London have more opportunities, but I think we're all getting busier and busier, and I think the Institute gives us a breathing space, if you like, and an opportunity, I think, to meet each other and to engage in conversations outside the box without having a specific immediate goal, and that is, I think, hugely important, supremely important. Finally, I would like perhaps to open the discussion up and to say what next for the Institute, and I think that is a big question and not an easy question to answer, because the Institute is doing a lot of things magnificently, all the things that we have mentioned so far, but is there space for diversifying? Is there space for adding things to the agenda, or is there space to do things in a different way? I was interested when Diamond mentioned the cross-disciplinary research. you are ideally placed within the School of Advanced Study with a number of other institutes. An existential question for the institute is what it can do differently, or what can it do something that, for example, a London Law School cannot do. And I think that's a key question. Interdisciplinarity is very important in my view. It's also very trendy. I mean, in the introduction you mentioned that we have established a faculty level institute at Queen Mary this year, aiming to enable conversations between our different schools within the humanities and social sciences, and also beyond this faculty, and conversations also with the Faculty of Science. And this is very important for a number of reasons. But maybe this institute is ideally placed really to help us further, both in conversation within the University of London, but also to engage with the individual law schools across the country in order to better engage in this conversation. Thank you for your attention.
Thank you.
And Professor Sutherland.
Well, thank you very much for inviting me. Thank you all for coming. I've made quite extensive notes, and I'm just thinking maybe I'll jettison them. My main, my starting point really was to think about how we can locate the institute and where it came from. And I was thinking that I could see it as part of the sort of wider institute movement, which takes off after the Second World War. And then I was listening to what you were saying there, and I was thinking, oh dear, that doesn't quite fit. But it still seems to me that, you know, we have this post-war optimism, we have this stress on internationalization, we have this interest in modernizing society generally, but also sort of modernizing scholarship, breaking down disciplinary boundaries and enriching scholarship, and that produces the institute movement, and obviously we have to locate this institute within that movement. And I went on the website and was looking at the general aims behind the establishment of institutes generally, and picking up three key points really. Democratic, so that these institutes should be open to all who feel their research has something to contribute or gain from institute resources and the intellectual association with their peers. Comprehensive, offering support at all stages. Altruistic, its primary purpose being support work not of its own staff and students, but members of other institutions. And I was thinking that's really interesting. And then, because I want to conclude by thinking that there, in a way, we have a sort of statement of a furtherance of the Enlightenment project, you know, and then thinking, well, so where are we now? And so I want to sort of finish with that, thinking, which I hope will, you know, underline how absolutely crucial the Institute will be. So, yeah, looking at its origins, but also looking forward. And so I suppose I finish on a gloomy note, but I'd also like to say, before I get on some of my points, what a wonderful thing it is that Diamond's been appointed, because you look around this room, and what we have, of course, is portraits of 5 white men, and we finally have a black woman, you know, and I think that's, obviously, that is also, I hope, a sort of illustration of the way in which we have to understand the Institute and the way it's evolved and the way what its role in legal scholarship has been, again, it has to be located in its times, which are good and bad times. Okay, so then I was thinking, you know, let's think first as well, though, why the Institute movement was, I would argue, particularly significant for law, really. Because if we think it's generally an expression of the recognition of the need to modernise and enrich academic scholarship, disseminate that work, etc. You think, well, law, of course, as we know, was a closed domain. It's what Larson, the great scholar of the profession, called institutionalised cognitive dissonance. And then secondly, we have the point that precisely because of the enclosed nature of traditional legal thought, it operates within authority rather than inquiry paradigm, thinking of the work of Samuel. And thirdly, of course, we've got the conflict, which in all these points I think are connected, which is bedeviled the discipline, i.e. liberal art or vocational training. And I think, you know, well, I'll go through these in turn. Thinking about Larson's description of law as institutionalised cognitive dissonance, what she does is she contrasts law with medicine and says, you know, we have two disciplines here, both of which are characterised, of course, by intellectual inquiry, but are also about training for professions. But with medicine, we have epistemic unity. By contrast, she argues, that actually in the realm of law, we have disunity, even though, of course, it's bounded disunity. And so she relates that to the different functions which law plays and which different professions within the law play. So she thinks about the judiciary frequently can be seen as a servant of the state, okay, also standing up against the state, the private practitioner, an officer of the court, but also actually a zealous advocate, and so on. But then, of course, there's, which I don't think she does talk about, then you think, well, law intrinsically is necessarily ambiguous, open to various possible interpretations, etc. So we have this institutionalised cognitive dissonance, and the fact that that therefore should, in theory, you know, make it absolutely the most fertile ground for legal scholarship and for the inquiry paradigm. And what's interesting is to think that up until, certainly I'd say, you know, the mid and late 60s, that potential fertility is constrained really by my second and third points, namely the fact that the juridical field could be described as closed and autonomous, governed by positivist criteria. So as David Nelkin said, even when law is thought of sociologically, it really possesses it and fulfills it through its own criteria of significance. And it seems to me that then clearly leads into obviously the primacy of black letter law, which supports the focus of law in education on vocational training and law's related dependence to and subservience to practitioners. And so thinking about where the Institute comes from and the Institute itself, you think what you have, of course, don't you, is this sort of breakthrough whereby a whole range of social forces both produce or support a further sort of flowering of the Institute and an opening up of law and legal knowledge by making them proper objects of inquiry in the liberal arts and highlighting the complex relationships between law, culture, society, politics, etc. And so I think, and what I'm trying to say, of course, is that the Institute is absolutely is part, I think, of that wider movement, that seismic change, which obviously doesn't happen overnight, which is an ongoing process. But it's also, absolutely key in driving it forward. And I think I identified 4 ways in which it seemed to me that it did that. First of all, acting as a facilitator, bringing people together, as you've said, developing new fields, but also reconstituting more conventional ones, furthering internationalisation, and providing a neutral space in which to pursue legal research. And I think obviously that also has become increasingly important, as I'll say later on. So the Institute is a facilitator, bringing together London, the rest of England, UK, abroad, etc. And that, I think, speaks to this emphasis on the democratic nature of the Institute movement, the democratic nature of IALS, for instance, through its outreach work, library roadshows, support for PhD students in law across the UK, and of course internationally, and the provision of legal research skills training elements. I came across one for the LLM in Paris programme, and then also a new LLM focusing on maritime and shipping law in Piraeus, Greece. So also a facilitation in the sense of bringing together people within and between disciplines, which we've already heard. And as Fiona mentioned, so Learn is a classic example, and the work, for instance, that William Twining did with Aaron Sher on legal education. But then also the way in which, as a facilitator, that it was also able to operate as a hinge, if you like, between legal academia and practitioners, and specifically doing that often through visiting, often international fellows, lunchtime seminars, evening lecture series, and so on. And so again, I looked for some examples, and I came across a lecture 2 years ago by the Inter Court Judicial Fellow Justice Azahar bin Mohammed of the Federal Court of Malaysia on reform of courts in Malaysia. And then in 2016, a symposium on the Judicial Committee of the Privy Council case papers, organised by the Institute, University of Reading, London Legal History Seminar. And the audience this attracts, again, shows, you know, the way in which it reaches out to this extraordinarily broad audience. So information professionals, legal practitioners, members of the judiciary, legal scholars, researchers, and members of the public. Truly democratic. Also facilitator in that it partners with overseas institutions, library cooperation, managing research projects, etc., e.g. the Columbia programme, which sounded fabulous. Conferences, of course. I mean, we've already mentioned the WG Hart Workshop, and the fact that that was the Institute was a pioneer, effectively. This was one of the first legal conferences as we know them. And it's extraordinary when you look at the list of topics. I mean, it exemplifies what I'm saying about, on the one hand, coming up with or exploring new topics, but also reconstituting, looking at older ones as well. And so I was looking at lawmaking in the EU, 1996, year before, liability, regulation, and risk management, reorienting the legal debate, access to justice in 2007, concepts of property law, understanding human rights. I mean, it's just fantastic. It is truly comprehensive in accordance with the state of date. So that rich diversity of topics, as I say, underlines what I mean about the second way in which it does this, by developing new fields, reconstituting more conventional ones, and thinking about that again. You could think about some of the work that key individuals have done, such as Terry Hickman, Barry Ryder, Avron Sher, and of course what you're doing. And the way in which so much of this work is pioneering, is breaking new grounds. And then there's this incredibly rich variety of seminars. Again, I tried to pick out, ones which seem to exemplify different ends of the spectrum. So on the one hand, 2016, the future of commercial contract, European and comparative perspectives. 2017, socio-legal sources and methods for family and social welfare law. The third way in which I think the IALS has been fundamental to the internationalisation of legal studies, of course, as a centre for foreign visitors. And I think that's what's interesting there is that in the early days they tend to be visitors from the Commonwealth, and now obviously far more widespread. But in that way, you could argue the Institute played an important role in the story of colonialism, neo-colonialism, empire and globalisation, in thinking about colonialism, and in an example of that ongoing engagement, I saw in 2015 the completion of the Indian legislative drafting course. Of course, it's already been mentioned, the library, I think you mentioned it too. The library is clearly extraordinary. In 2016, received the Wallace Breen Memorial Award for Excellence in Library Services. I noticed it's got, this incredible range of historical work, Grotius, Proof and Law, etc. And then equally, of course, its use of technology. Eagle eye, I said, I can't imagine myself getting to grips with this, but it looks very impressive. And then, of course, there's the Institute's pioneering move into doctoral studies, which you mentioned, and research training, at a time, as you said, when, on the whole, practitioners, legal academics didn't have doctorates, and now it's impossible really to imagine being a legal academic and not having a doctorate. And the numbers of doctoral students have averaged at any one time 50, and that obviously in turn generates a huge wealth of different subjects. And then there's the work of an academic publisher across a broad field. And then the fourth way in which that I want to that I mentioned, that I felt the Institute made a specific contribution, was by this provision of a neutral space. And I want to just now, think about then what this means, what when we think about the current situation. So thinking about those different claims, those different objectives that are spelled out, broad and freely associating community, democratic, etc. Well, I mean, obviously that's a vision of collegiality, isn't it? Which I would argue is far less easy to maintain, to sustain in the days of ref, managerialism, the incredibly competitive and pressured nature of academic work in universities and law schools. And so obviously that absolutely underlines the significance of the Institute as a neutral space. Hopefully, counteracting to a degree to the extent to which the ref has been destructive of that collegiality. And then thinking internationally, the aspiration of a broad and freely associating community. Clearly that's challenged by Brexit and a general retreat into xenophobic parochialism. Again, democratic, open to all, altruistic, these are the terms that are used. Well, you think of the impact, going back to academia, you think of the impact of managerialism on academia, the impact of marketisation, the impact of fees. On what we were talking earlier, about how, as academics, one still regularly does things as part of good citizenship, reviews or acting as external examiner. That's an example of that altruistic ideal that inspires academia. And yet actually, often the journals that you're doing it for are money-making machines. And it's out of sync, and it's very worrying. But I think most important, really, for me, thinking about what the Institute's done and what its aims are, is thinking about the absolutely vital significance of empirical research and trusted sources of information in this age of post-truth. I mean, and then, related to that, I think, is when you think about the ongoing transgressions of the rule of law, the rise of populist nationalism, which I've already mentioned, and the creeping erosion of civil law, the way in which large corporations appear to have immunity to lots of national law, or the shutting down of access to justice for others. And to borrow Martin Kruger's phrase, so I think what we see is wild, extreme, intemperate power and abusive constitutionalism becoming far too common, bringing new urgency to the study of law and the support for understanding law as a distinctive domain in the exercise of power, i.e. for paying close attention to what difference law can make to the ways power is exercised. And obviously a recent example here is the way in which judges are the enemies of the people. So I think the Institute has played this absolutely vital role, this influence on policymakers, this hinge, say, of practitioners, this way of furthering the value of law, the value of critical inquiry, and that crossing boundaries, and it's more needed than ever.
Thank you so much for those three very insightful contributions. I'm wondering if between three of you have any comments or thoughts inspired by each other's interventions before I open it up more broadly.
It's a bit of a challenge, isn't it? It's like doing an exam. You're all sitting there. Now what are they going to say? Yes. I mean, I suppose I was interested in Hilary's comment at the beginning that she was going to talk about the Institute as part of this Institute movement, and what I've been talking about didn't quite fit. I think it did fit, really.
I just meant that you got down to the detail, which I haven't, about how it started in the 1950s. I think it was the University of London that reflected the optimism and the new beginnings that you talked about.
Yes. I think it, not for the first time in the history of legal education, the politicians were not so keen on the enterprise, which I thought was kind of interesting, really. Yeah. I think those are my thoughts.
No, I just suppose that I thought it was interesting that actually the idea had been had before what I felt was this sort of, this enthusiasm for transforming intellectual inquiry following the war.
Yes. So in 1932, basically.
Which is, but maybe it had very different origins. The way you talked about it, I see how this is actually different from the Institute movement in some ways. It's a different project.
Well, it is a different project. It was a different project, but I think it really played into that. It would, and would have been quite happy to be subsumed in it. But what was interesting to me was how legal education itself and legal education research were in the doldrums at the time. So, as you were saying, everything was very narrow and doctrinal, and nothing else was very tolerated. And then after the war, here was this institute, very outward looking. Which, is really...
like society.
Yeah.
I mean,
Really, I mean, it may sound a more esoteric point, but it has to do with openness as well. And I think you mentioned that it was an experience at the University of London. And I think for us who are members, if you like, in one way or another, of the University of London, this is something that is also, I think, something that is forces us to rethink: do we really belong in the University of London? If we are at Queen Mary, at LSE, at SOAS, and so on, are we really separate universities? And I think this forces us in a good way, really, to talk to each other more and to think about our own identity, because there is a very big existential question about, is there the University of London nowadays, and if yes, what role does it play? And I think this is a very good example of the role that the University of London as such can play.